It's time to get that inventory over to the probate court. Hi, I'm Darren Findling of the Probate Pro, and let's examine the inventory in a deceased probate estate. We're going to explain how to complete it, what information needs to be included on it, how to get it over to the probate court, and how to get access to the form itself. Let's get right at it. The inventory is a form, a state court administrative order form, a SCAO form. As referenced in the bottom left corner with the yellow arrow, it is a form that is SCAO form PC 577. This form is not the same form that's used in a guardianship or conservatorship context. That's a different SCAO form. This form is used only in a deceased probate estate. Now, with all of the SCAO forms, they are readily available. You're welcome to contact my office. We'd be happy to provide it free of charge. It's also available on my website. And this particular form was recently updated. And if you look at the REV date at the bottom left corner where that yellow arrow is, it says revised in September of 2020. It was supposed to be mandatory in July 1 of 2021, but most of the courts are allowing these forms to still be used up through 2021. But we strongly urge you to use the most current forms, because we've even filed some of the older forms that were signed earlier, and some of the courts are rejecting it. So use the most up-to-date form. And this particular video is being done because I have done videos on this particular subject with the most up-to-date revised form through September of 2020. With all of the state court administrative order forms, they are created by various statutes and court rules. And here you'll see MCL 700.3706, 3707, and then the Michigan Court Rule, MCR 5.307 and 5.310 and 5.409B. That's a lot. So when you see court rules and statutes as a layperson trying to navigate through this, it really is a time for me to say to you, please use a lawyer. Work with a skilled, competent probate practitioner who knows how to navigate through this particular area. The probate administration is not simple. It's not intuitive. There's no guidebook. In fact, the entire statute book of EPIC with the court rules is really a lifelong learning. I go to it almost daily to try to understand some of the nuances of it. But we're going to give you a really good understanding of the inventory and how to fill this particular form out. Let's get right at it. In the top left corner is the county. It's the county in which this probate proceeding is occurring in Michigan. Now remember, this inventory is required to be presented or filed to the probate court within 91 days after the appointment of the personal representative. What do we mean by that? Presented or filed? Well, you have every right to file it, which means you're making it of public record within a probate estate, but you can also present it to the probate court. The rules provide that as long as the estate is not a supervised administration, that the inventory itself is a private document, and that the probate court's involvement in the inventory is simply to review it for purposes of determining the gross inventory fee that has to be paid to the probate court, which is kind of like a tax that's being paid based on the valuation as set forth on the inventory. This causes a lot of confusion because people think, oh, I have to file that inventory with the court. Well, no. In an unsupervised estate, assuming that there's no court order that mandates the filing, the inventory can simply be presented to the court. The court reviews it to make sure it's filled out correctly and that it contains all the requisite information for the court to determine the inventory fee that has to be paid when presenting the inventory. And then that document is actually returned back to the personal representative or the filer or presenter in this particular case, and never becomes part of the court record. On the other hand, if it's filed, it's public record, which means anyone can see it. And the idea behind this was that the legislators wanted for informal probate administration unsupervised administration for the assets of the person that has died to remain private. Private unless there is a requirement for it to be either a public record or to be shared to a broader view. So this is not to suggest that the inventory for presentation or filing doesn't get served. No, on the contrary, the court rules mandate that all of the interested persons as defined within the court rules must get served with the inventory. So think of it like this. There may not be a requirement to file, it may just be presented, but the requirement to serve all of the interested parties with the inventory is a requirement of the personal representative. In the top right corner is the case number and the judge that's assigned to the case, and in the red rectangle, I've identified whether it's the original inventory, the first inventory, or whether this document has been amended. So, for example, if you present or file an inventory and then you learn of additional assets that existed as of the date of death, you would file an amended inventory, and that little checkbox can be checked. Now, as we work our way through this document, you'll see that there's a requirement for you to identify the court address and court telephone number, and then where it says in the matter of, that's simply the name of the decedent. So, for example, the estate of John Doe, or in this particular case, it could say in the matter of John Doe, comma, deceased. Then, in the rectangle on the left is the personal representative's contact information, name, address, telephone number, and in the right, if there's an attorney that has been hired on behalf of the estate and has filed an appearance, that's the information that goes there. Now, again, strongly urge you to be working with a lawyer because this stuff gets quite complicated. In the section below that is the name of the person that is completing the inventory, in this case the personal representative, and that they're submitting the following as a complete and accurate inventory of all assets of the estate. And the estate means the person that died, the individual that died. That word estate gets confusing to many people. But let's understand what that means when we speak of an inventoried asset as of the date of death. The only assets that make their way onto an inventory are assets owned by the decedent in their individual name with no named beneficiary. So, for example, if somebody owned an asset like a life insurance policy and they named a beneficiary of that life insurance policy, then generally the inventory does not include that asset. That asset goes pursuant to the contract of life insurance directly from the person that died to the beneficiary claimant, and it is done directly through the life insurance company. It is not a probate, or as we would say as lawyers, a probatable asset. In addition, as I was describing those assets that are assets that make their way onto an inventory, an asset that has a joint name. So for example, a house that's owned by husband and wife as tenants by entirety. The husband dies, there's no need to inventory the house because the wife is the survivor, and that would hold true with any joint account or survivor asset. So a bank account, for example, that is a joint bank account pursuant to the bank account titling and contract would go from the decedent to the survivor by simply presenting a death certificate to the financial institution to release that money to the joint owner. It does not go on the probate inventory. It is not a probatable asset. And then, of course, assets that are titled outside of the decedent's name. And the most common would be an asset that is in a trust. So, for example, if you do appropriate estate planning and you have identified that all your assets are funded, or you have funded all the assets into your trust, trust assets are not probatable assets. So we're only looking for assets titled in the name of the decedent with no named beneficiary, no joint account holder, in their individual name as of the date of death. Those are the assets that are going to be reflected generally on an inventory and presented or filed with the probate court. And again, we're talking about the date of death. So assets that come into the estate during the administration, this sometimes occurs, would be reflected on an accounting. The inventory is a snapshot. It's a snapshot as of the date of death. So everything from the inventory forward would then be reflected generally on an accounting, either an interim or an annual accounting, which is another scale form, which I've described in another video. So again, date of death assets only in the name of the decedent. Now this particular section of the inventory is the one that causes a lot of people consternation and frustration. So again, what we're going to talk about here is the first two lines, which is when there's real estate. So what is a legal description of property? What they're referring to, real property is land, a house. That is what we call real property, distinguished from personal property, which could be, for example, cash, bank accounts, jewelry. A legal description is the formal legal identification of the real estate as would be reflected at the Register of Deeds. So you can find this information generally on sometimes on a tax bill, on an old deed, on a mortgage. It sounds something like this. Lot 309, Johnson Murphy subdivision, as recorded in Liber 16, page 9 of the Wayne County records. That's the legal description. It could also be a meets and bound description, a real formal description. And there's not a lot of room there. So if you need additional room to legally describe it, use a separate supplemental piece of paper to do so. The gross value is the value of the real estate without identifying any liens or encumbrances. So the gross value, the court will accept 2 times the state equalized value. That's not the only way to value real estate, but the court will accept it. So the way you get that is you go to the year upon which the decedent died, and you look at the property tax bill, take the state equalized value, multiply that by 2, and you get a gross value. Now, if there's been an appraisal, then an appraised value would be appropriate. If the house has been recently sold within a short period of time, you can use that as the gross value. Now, the lien amount is the next column there. These are any home equity lines, mortgages, liens that encumber the property. We call these secured interests. That lien amount is a reduction in the gross value. So for example, if the house is worth $100,000 and there's a $95,000 lien, then the inventory at the far right would be simply a $5,000 net value. We call that the equity value or position of that particular piece of real estate. So if there's an appraisal, include the appraiser's name and address and a description of the property that was appraised. And it's really important because the court will often reject how you identify the real estate. So you have to be very careful about getting the legal description right, making sure that you've included, if you're using 2 times the SEV, a copy of the tax bill for purposes of determining the gross value, and then any liens are appropriately identified so that the court can be assured that the valuation that you're using for purposes of that real estate are accurate, because this is an important piece for the court's function, is to identify the gross value for purposes of assessing the inventory fee. There can be multiple forms of real estate, and there's space just for 2, but again, if you need additional room, include it in a supplement. Then there's the description of the personal property. So with description of personal property, again, there are times, for example, if there's an automobile, which is a form of personal property, that there could be a lien. So very similar to what we did in the earlier section on real property, we're going to do the same with personal property. And we're going to identify the value of the personal property, any encumbrances or secured interest relative to it, and then the inventory value. So where this gets quite complicated is automobiles are listed here, jewelry, bank accounts, antiques, things of value. But where the people get stuck here often is, for example, if there's a house and the house is filled with contents, they are concerned, do they have to list each pot and pan? And that can be quite difficult to do. So there are some strategies around how to address that issue, and you're welcome to contact me. But don't describe and don't put on this inventory information that would, if made public, would violate somebody's privacy or put that person at risk. So for example, don't include full account numbers for bank accounts, because people can go into these public record files and identify the bank account, social security number, and date of birth, and there's a risk of theft. So the court has established through another form a personal property information separate form that allows you to identify and disclose private information. So you want to redact that information that could put the individual or your administration of this estate at risk. So you don't want to disclose those types of really detailed property information. Now, as you fill out this inventory, there is a total at the bottom right corner. First, for the total gross value, you're essentially adding up that entire column down, the lien amounts, and then of course the inventory value, which is the total inventory at the bottom right corner. And that total number there is going to be the number that is utilized by the probate court to assess the gross inventory fee. That gross inventory fee is a formula, and it's based on a table. And again, we're happy to provide that information to you. You can also find gross inventory fee calculators throughout the website, including our own website, and the court calculates that, and that's a fee that must be paid to the probate court as part of the administration of the probate estate. And again, it's really just important. I can't stress it enough that you do this piece right here, because you're stating, as you'll see in a moment, under the penalties of perjury, that the information contained is correct to the best of your information, knowledge, and belief. So you have to do your due diligence. And people will call us and say, well, how do I know what my dad owned? Where do I go to find all that information? And again, not an easy answer, because there is no one central depository or database that identifies where people own things. Often, we can go to a credit report to identify liabilities, but there's no one place to go to find assets. So we strongly urge you to monitor the mail, because you'll see bank statements, you'll see renewal notices, you'll find life insurance. Monitor email. Check local banking institutions that you think the person may have contacted. Remember, if you go to a banking institution with your letter of authority and there's nothing there, essentially you've just wasted some time, but at least you've identified whether there's an asset there. So you can go to various banks and identify and do a little bit of a kind of a search for assets. You should also check the unclaimed property division, which I can explain, and we've done so in separate videos, not just in Michigan, but in other states. Which brings me to this point that the court has only jurisdiction of certain assets that are in Michigan. So for example, there may be real estate in other states or in other countries, and you may need to do what's called ancillary probate administration, which again, we explain in a separate video, and those assets may not be within the jurisdiction of the state's probate court through your probate administration. Again, this is just a very high-level understanding of this inventory. I can't go through all of the statutes and court rules, obviously, and we strongly urge you to be working with your probate practitioner as well as reading those statutes that we identified. Because at the end, you're signing a declaration under the penalties of perjury that the information contained is true to the best of your information, knowledge, and belief. And anytime you sign a document with the court, there are penalties relating to failing to disclose relevant information. So we just strongly urge you to fill this section out correctly. So then you've got this document completed. It's signed by you and your attorney. And then, of course, it's either presented or filed with the court. And then according to the court rule, it has to be served on the interested parties within the estate. And a proof of service is then filed. And that proof of service, again, I've explained in a separate video. It's a separate scale form. That proof of service is completed, and then you have fulfilled that part of your responsibility relative to the presentation or filing of the inventory and serving of it. So hopefully this gives you a broad understanding of the inventory process in a deceased probate administration. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular form or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.